First matter to come before the court is in re adoption of K.N.S. As you know, each party will have 15 minutes to present oral argument. The appellant may proceed first and may reserve up to 5 minutes for rebuttal. Let me just get to where we're going here. Okay. If you wish to reserve any time, please let me know as I'll be keeping time.
I'll reserve 5 minutes, thank you.
All right. We've read the briefs. We're ready to proceed.
Apologize to the court for my tardiness. I haven't been in that area in so long I got lost.
The traffic patterns aren't easy either.
No, they aren't. This is from the decision of the trial court from in re Lassiter.
It's good appellate practice to introduce yourself.
Oh, I'm sorry.
Plus, I think you're on, you're being recorded, correct?
I would assume.
Aren't we recording these?
Yes,
for-
we are.
Okay.
Thank you, owners.
Yeah.
My name is Steve Bailey. I'm here for the appellant. This is from the trial court's decision from in re Lassiter, quoted with parent approval. Drug addiction does not relieve one of one's responsibility towards his family and society. A drug addict still must pay his rent. A drug addict still must pay his bills, and a drug addict still must pay his taxes. Appellant apparently finds sufficient to support his drug habit, finds funds sufficient to support his drug habit, and therefore he should have had funds sufficient to pay support. A drug addict must still abide by the rules and laws in society. I respectfully submit, Your Honor, that that statement is an anachronism and intellectually vapid. It is contrary to common sense and logic. When I first agreed to take on this appeal, many of my colleagues said, good luck, you're going to stand in front of the 9th District Court of Appeals and argue that a drug addict should be excused from supporting her child. I hope and I trust that Your Honors know that that's not what I am saying. What I am saying is that drug addiction is a disease, like alcoholism, and that this court ignored that reality and drew a bright line standard for the 1 year of support in the adoption statute that was not realistic or fair to this appellant. If Danielle had been in prison for a year for drugs, she would not have lost contact with her child for the rest of her life at the age of 29. She had warrants out for her arrest from, I believe, 5 different jurisdictions during this time. She was living on the street. She lived day to day, trying to support her drug habit. She was no more able to support her child than had she been in prison. The fact that she hadn't been caught is a distinction that I do not believe is appropriate to accept in the law. If a person who is incarcerated is found to have justifiably not supported his or her child for a year, how can we then say that a person who is in the throes of a helpless, hopeless drug addiction has to be held to that standard?
Counsel, would this, would our consideration of your argument be different had you brought in an expert witness at the hearing stage who was, let's say, a psychologist who had a background in addiction all of the things that you're raising, who looked at your client and her specific situation and opined that she was absolutely without the ability to maintain employment during the year before the petition was filed, would we be in a different kind of situation?
It would have been highly preferable had trial counsel done that. I agree with you. However, Your Honor, I don't think you're in a different position, because what trial counsel did do was elicit from my client extremely detailed accounts of her daily life. And the fact that she was living on the street, and the fact that she was stealing to support her drug habit, and the fact that she didn't have money for food, and that she was living a basic day-to-day quest to support her habit. I do agree with you. I wish that there had been expert testimony. But I don't believe this is something that absolutely requires it. We're all human beings, and we can all understand what she was going through. We can understand from her own testimony what her life was like. We may have friends, we may have relatives that have gone through addiction or alcoholism, and it is something that within a lay person's knowledge, I believe we can all understand. Yes,
You yourself just used the word habit that she had. One of the words in the definition of dependency is the faults or habits of the parents. I mean, a parent can lose custody of a child because of their own faults or habits, which don't even necessarily include drug addiction.
Absolutely.
Something as simple as a filthy house could make you lose your children.
Well, I'm going to jump ahead here a minute, because you're raising an issue that I was going to come to in a bit. Because if one looks at the differences between the dependency, neglect, and abuse standards, it highlights the argument that I'm trying to make here, especially in regard to the constitutionality of this statute. We have a constitutional scheme in Ohio where if Danielle, because of her drug addiction, had left her child alone in a room, locked in a room with no food and no water for 3 days, she would still have the opportunity to come before court and prove that within a reasonable time she could be reunited with that child.
And wouldn't by statute that be a year? And wasn't it by statute in this case as well, a year of non-support?
No, by statute, she has an opportunity to come before the court and prove that she could, within a year, be reunited with her child. When this case came on for hearing, especially the second hearing, the best interest hearing, she was in recovery. She had 4 years of sobriety. She was in 2 different drug programs. Had this been a dependency and neglect case, her rights would not have been permanently terminated.
Well, with due respect, it appears back on February 11, 2010 in domestic relations court, there was a hearing granting temporary custody of father. And I mean, there was an ongoing thing in domestic relations court all this time, contemporaneous, prior to what happened in probate court.
Absolutely. But
Not
domestic
contemporaneous,
relations
but prior
court,
to.
domestic relations court, Your Honor, under no circumstances could ever have terminated her parenting rights forever at the age of 29. They couldn't have. That can only happen through the juvenile process or the adoption process. And the juvenile process and the adoption process are so different that I do not know any way that one could argue that the adoption statutes are as narrowly tailored as necessary, or as possible, I should say, to meet the government interest involved. Because the juvenile statutes are more narrowly tailored. And so therefore, in our adoption statute, she never gets an opportunity to show that she's in recovery. She never gets an opportunity to show that she could reunite with a child within a year, because that's not part of the statute. And to me, when you say a parent who abuses a child has more of a right and more of a chance to keep from losing her parental rights forever than a person who is subject, their child is subject to an adoption, there's something wrong with the statutory scheme. When we start with the premise that parental rights are fundamental and therefore can only be deprived by a statute that meets a compelling government interest and is as narrowly tailored as possible to meet that interest. That is why I believe this statute is unconstitutional. But going back to...
Let me raise a question as to whether or not the record before us would allow us to rule on the constitutionality. I mean, you're arguing very persuasively today on that issue, but what is in the record from below, other than a statement, an argument that was made at closing about the constitutionality?
I understand the question. I anticipate the question, obviously, as part of the appellee's brief. I believe that it is a close call. I'll give you that. But I do believe that the comments made in opening statement by trial counsel in the initial phase, in the consent phase, were sufficient to raise the issue of constitutionality. Trial counsel specifically raised the issue in his opening statement that this was a fundamental right and that it could only be deprived under compelling circumstances. And it will be for this court to determine whether that sufficiently raised the issue of constitutionality and preserve it upon appeal. I took this appeal because I believe two things. I believe that the statute was unconstitutional. When I looked at that dichotomy between what a person has to do to lose their rights forever as an abuser versus a person whose child was subject to an adoption. But I also took it because I believe the trial court simply did not give enough weight to the evidence of her addiction. I mean, if you look at the facts of her life in the year before this adoption petition was filed, it is beyond question that she could not support that child. Now, if we want to say, as Lassiter did, what's her fault? She was a drug addict, she could get her drugs, so she ought to, in cross-examination, opposing counsel, not this counsel, but trial counsel, said, well, why couldn't you have stolen those things and paid your child support with them? I mean, realistically, she couldn't do it, and she couldn't do it because she had a disease called drug addiction. But a disease of drug addiction is not for life. It's not. We all know that. Drug addicts recover. Alcoholics recover.
And to that point, that takes us back to the argument that you made a few minutes ago that we know people who have been addicted to drugs. We also know people who have recovered and have remained clean. And so where do we draw the line?
I think, Your Honor, you draw the line exactly the same. It depends whether we're talking about the constitutional argument, in which case I think it's a legislative problem that has to be solved by the legislature.
Sure.
I may do. If you're talking about the findings of the trial court, you need to draw the line in the same place that you would somebody who was in prison for a year. I mean, you're in prison through their own fault. What's the difference? But the law is very clear these days, in 2016, that that is a justification for not supporting a child for a year. So why can't we draw the line in the same place?
I apologize. You asked me to reserve 5 minutes, and we've engaged you and went into that time. But we will give you some additional time.
Thank you, Your Honor. I appreciate it.
Good morning, Your Honors. My name is Attorney Rebecca Clark, and I'm here today on behalf of the appellee. The appellant's brief mentions a few things, and this court has really gone into some of the things I had in my brief, such as whether or not the constitutionality argument was properly preserved at trial. So I won't waste any further time going over that portion of my brief, but I will step a little bit into the constitutionality argument so as to defend it should it be found that it was properly preserved. Drug addiction in and of itself is not voluntary. I don't think anybody here would argue that. However, the act of feeding that addiction, the act of giving into that addiction, the act of being sober at some points and using at others, that's wherein is in the control of the addict. Mother appellant testified very clearly in her own testimony that she had a period of sobriety, that she had a period when she was using and providing for her daughter, and that she had periods when she had no control. This indicates that her addiction was not so hopeless that she couldn't control it. It just appears that she picked and chose what she wanted to do. The domestic relations process had been going on for 4 years before the petition was filed. So in 2010 through 2014, mother was in front of the jurisdiction of the domestic relations court, sober, not sober, sober, not sober. Her visitation was suspended during periods of time, her custody was taken away, and yet none of that inspired this sobriety, this change of life that counsel would like to present as being possible, as being relevant, as being important. I'm extremely familiar with the abuse, neglect, dependency statute. I practice in juvenile court on a very regular basis, representing parents whose children have been removed. So when you look at the A&D argument versus the private, the custody, and the adoption end, there's a different standard, but the goal of the state is exactly the same. It's the compelling interest in permanency, protecting the childhood of the child as much as it is possible. So on the abuse, neglect, and dependency side, those cases are open for a year, can remain open for as long as 2 years if there's substantial case plan compliance. Again, to give the residential parents, these are parents who have custody, to give them that opportunity to reunify. In the adoption side, it only affects parents who already have custody. So in this case, mother had already lost custody. So someone had been through a process, in this case father, to obtain custody, to provide for the child, and then the stepmother to move in as the adoption. So it's not the same argument. We're not dealing with children who have parents who are not capable, who are struggling, who need that assistance from the state. We're dealing with parents, children who have a capable parent and an incapable parent. And a court has already deemed the capable parent is able to provide for and give that support to the child. So it's not the same process at all. And it shouldn't be relayed to this court that mother, if given more time, would have had every opportunity. She had every opportunity. She had the opportunity even at the trial court level to present her case that drug addiction totally disabled her from providing support. She presented that evidence. As the court pointed out, she didn't bring in an expert witness as to her specific case. And we know that these cases are case by case and judge by judge, that it is under the discretion of the judge as to whether or not it's justifiable cause. So is it possible for one petitioner to present different evidence than another and the outcome not be the same? Absolutely. But again, that's the responsibility of, in this case, mother as the appellant, to come before the probate court at the trial level and explain why her circumstances are so very different that the adoption should not be allowed to continue without her consent. Her capability to provide support is proven time and again in her own testimony. She had several jobs. She lost them because of her criminal activity. She was not disabled in the sense that she couldn't work. She just chose not to when she was on the run from the law. Being a fugitive is not to be an excuse for not providing support. When you talk about someone who's incarcerated, they're serving the time that gives them that opportunity to get sober. They're taking responsibility, or in some format, paying the price for their crimes. The fact that mother intentionally deceived the law, intentionally ran from the law, intentionally did not take any responsibility, is another reason why this court should give no discretion to, the trial court should give no discretion to the fact that she didn't provide support. So this is someone who's honestly in the throes of an addiction, and I understand that. And someone who has the capability to provide because she's providing for her addiction, but chooses not to. And then wants this court to say that 1 year look back is not fair. As to the constitutionality, there are not many states who have this constitutional bypass. The majority, vast majority of the states have, it is impossible to have this route to an adoption to terminate parental rights, because we all agree parental rights are fundamental. But since the inception of this particular statutory concept, it's been revised 4 times. Because again, over and over and over again, we are trying to narrowly tailor. We are trying to get it perfect. And so I think that there has been significant effort on the part of the state and on the part of the courts to define this as narrowly as possible. We're not trying to create a statutory concept whereby an active, engaged parent who simply doesn't have the money would lose custody of their child. What the state is trying to do is trying to stop parents who do not have the capacity for one reason or another, who do not have the capability and simply will not provide for their children or engage with them, from having the ability to later control and interfere with those rights of a parent who does those things, to continuously disrupt, to continuously create havoc for a child who is trying to have a childhood. So it is, I believe, incredible that someone from the appellant standpoint who admits that she can control her addiction, stay sober, and then use when she chooses, who chooses to be a fugitive from the law, who has warrants out for her arrest, can come before a court in this state and say, I should have been given more time. This statute is simply unconstitutional. It's not that it's unconstitutional, it's that in this particular case, mother didn't think it was fair. And so I asked the court to consider first and foremost as to the constitutionality, that it was not properly preserved, that it was raised only in an opening or a closing argument, and therefore is not evidence to be taken by this court. And to consider that in that two-step process, the trial court did find that one, she willfully failed because she did not provide, there's no question she didn't provide, but that the justifiable cause of her individual addiction was not sufficient to allow her to continue to be in this process, to force the need for her consent. I believe that's all, Your Honors.
Thank you. Counsel, you'll have 3 more minutes.
Thank you, Your Honor. First of all, I want to say that solving the constitutionality is really simple. All the state legislature has to do is add one more factor in the adoption statute, and that is a finding that this person could not rehabilitate themselves within a reasonable time. And then that is narrowly tailored. Then she has the opportunity, not to ask for more time, by the way, to prove that she has the possibility of rehabilitating herself. I want to go back to the question about domestic relations. This is not a custody case. Nobody is arguing that Danielle should have custody. Nobody. It is a permanent dissolution of her right to see her child at the age of 29 years old for the rest of her life. It is, as is stated, I believe in the trial court's decision, the equivalent of the family law equivalent of the death penalty. So trying to make it narrow is not good enough. And then also, counsel many times during her argument said choose to. Your Honors, who in the world would choose to live the life that Danielle was living? The answer is nobody. If it were a choice, we would not have a drug addiction epidemic in our society, because nobody would choose to be a drug addict. Nobody would choose to be homeless, to be looking for the next meal from day to day. It's not a choice.
Did she choose to avoid being arrested on K.N.S?
Yes,
Okay.
I believe the evidence one could reasonably infer from the evidence that she did.
And
Yes.
could we look at that as, I mean, obviously a calculated decision, but to your colleague's point, had she been arrested and not been on the run, she may have had the opportunity to begin the process of, being off of drugs, of sobriety, forced sobriety.
No question about that, but that's not what addicts do. That's not what addicts do.
Some of them do, but not all.
And people who have a disease are not in control of the disease process. And as I say, I'm sorry.
No, go ahead.
As I say, if the court had considered the possibility that she could recover, that she was in recovery, that she might have recovered, that therefore terminating her parental rights forever wasn't the appropriate remedy for this situation, and had concluded that no, she could not, then I don't think I'd be here. I don't think I would have taken this appeal.
Let me ask you a question though. I mean, you're saying she could at some point in time. This child's what, 7 years old?
Yes, sir.
Okay, so she's got 11 years left of being a child in her
Yeah.
life. Okay, there's no guarantee that mom's gonna clean up in the next 11 years. She hasn't cleaned up in the last 5, right? So
You're right, Your Honor. and that's-
anybody can recover from, and cancer can be cured. I mean,
Yes.
you could get up and walk out of a wheelchair.
Yes,
Everything is possible.
right.
But this child only has 11 years as a youth.
But Your Honor, that's what the domestic relations court was for. They were never going to give her custody or give her visitation until she demonstrated that she was clean.
But
That's what
about
they're
the-
for.
What about the child's need for permanence?
And the best interest factor.
There is a compelling state interest in permanence. There's no question about that. But we recognize that in the dependency, neglect, and abuse statutes. We recognize that need, but we give that extra push to the court to say, you gotta find that within a reasonable time, this person could not reunite with the child. It's very possible to serve both interests at the same time, and that is the definition of being narrowly tailored. That's the definition of it.
And you've reached the end of your time.
Thank you, Your Honor.
Thank you both for your presentations. The court will take the matter under advisement, we'll issue our opinion and send it to both sides. Do check the Supreme Court website and our website as we post our decisions.
Thank you.
Have a great day.